I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today we are knocking on the door of number 264 on our compilation list. For this compilation, we will be in 3 different judges' courtrooms. Before I give you their names, don't forget to like, comment, share, and subscribe as always. I appreciate you guys. Also, commentary will be left in if there were any commentary in these proceedings, and chapters will be added for your convenience. Now, the 3 judges' courtrooms we will be in. First, we will be in the courtroom of Judge Kathleen Lang out of the state of Indiana. Second, we will be in the courtroom of Judge Sheila Martin out of the state of Michigan. And last but not least, we will be in the courtroom of Judge Atkinson out of the state of Texas. Guys, let's keep these compilations going. Let's keep these views rising. Don't forget to share these videos, comment on them, like them, boost them, whatever you can to help us to keep this train moving. And listen, it's about that time to jump into 264.
Rights. I know my rights. I don't need an attorney. Thank you.
Right, Ms. Matlin, you are here today for an initial hearing. Tender to the court has been filed, notice living man, declaration of status. Those are signed by you and have been entered. There's also an affidavit of truth that is unsigned. And so anyway, we're here for an initial hearing and to make sure that you understand your charges. What is your date of birth?
I do not understand. I am here on a special appearance of Thomas Maitland in all caps letters on a special appearance of the case number of 46D04-2602-CM-0250.
Correct. But I need to tell you what you're charged with in this case. So first of all, how old are you?
I'm 29.
All right. What's your birthday?
You guys should already know that, correct, or no?
No, I don't. I don't know what your birthday is.
I don't understand.
I just need you to tell me.
Here's the problem. If we don't know who you are, there'll be a warrant issued for your arrest. So we're trying to get past that level.
Okay.
Okay, so state.
Then you didn't get these papers. I'm gonna give them to you.
Okay, so let's back up. My job is to make sure you understand what you're charged with. I have what you filed, and that's made a matter of record. What is your date of birth? Well, you know what? Let me see here. Okay. Hold on. I do have it. Is your birth date 9/29/96 and you're 29 years old? Is that correct?
That is my living man. Yes, that's when I was born, but not this all caps name that's on the docket that you sent me papers for.
Okay. Yeah. So your correct name is, I had that right here too. Well, you signed it, Bo Matlin, what you entered into the court.
Yeah, but not in all caps.
Okay. All right. That's noted for the record. We have an address of Lean, Michigan. And is that where you live?
I do not.
Okay. Where do you live?
That's me, my person, not this all caps name.
Okay, I understand that. We made a record of that, so that's not a problem.
Okay,
but what I need to know is if that's where you live in Collier.
No.
That's not where you live?
That's where the physical man lives, not the all caps name.
Okay. The all caps name I've taken care of.
Okay.
Right. I understand your concern with that. Taken care of. That's, that's noted for the record that that's not the way your name is. But what I need to know is what your address, so that you can be properly notified of things that are going on in this court. So what is your address? Is that where
Your Honor,
you live?
Your Honor and the prosecutor have taken an oath of office, correct?
Okay, this is not your time to ask, sir. Okay, so we have to make sure that we go through the right procedure. You filed all that, so I understand where you're coming from, so to speak. But what I need to do, I have a job, and I would be not upholding my job and what I am sworn to do if I did not inform you of these things. So I need to know if you live at Michigan.
That The living man does, not.
Okay, the
not
living
all
man lives
caps.
there, correct?
Not the all caps, there's two different. it's-
Right, no, the living man lives there in Galeen, correct? At that address?
I don't understand.
All right, when you go home tonight, where are you gonna sleep? Are you gonna sleep at this address in Galeen, Michigan?
That's where I reside, but that's not where
Right.
this corporation of my all caps name is.
Okay, so we've got that's where you live, so to speak. Then I also need to make sure that you understand your constitutional rights. So do you know what your constitutional rights are as a defendant in this court?
Yeah.
Everyone, the Constitution gives you certain rights that have to be followed, as a defendant here. So do you know what your constitutional rights are?
Yeah, I state on record my constitutional law, section 39329 is Chicago motor coach versus Chicago, Lagar Chicago versus Chicago, Lagar versus Chicago, 29NE934.
Okay, that obviously is not a case that would be applicable here because this is Indiana, but I need to make sure that you understand that you have the right to assistance of a lawyer if you want one. If you intend to hire one, you have to do within 10 days. And if any deadlines are missed or legal issues or defenses that could have been raised, could be waived or given up. If you're unable to afford a lawyer, the court will appoint one for you. You have the right to a speedy and public trial to the judge or jury. And if you want a jury trial, there has to be a written demand with the court 10 or more days before the trial date. You have the right to require the state to prove the elements of the charge against you beyond a reasonable doubt at a trial in order to obtain a conviction against you. And throughout these proceedings, you are presumed to be innocent. You have the right to hear and cross-examine all witnesses appearing against you. You have the right to require witnesses to be present at any hearing or trial to testify in your behalf. And the court would assist you in that right by issuing subpoenas. You have the right to remain silent. You cannot be compelled to make any statement or testify against yourself at any hearing or trial. Anything you do say could be used against you. You have the right to be tried in the county in which this offense allegedly occurred. You have the right to appeal to a higher court if convicted. You have the right to demand the nature and cause of accusation against you and to have a copy of the information. If you plead guilty, you would give up those rights. Now, I'm not going to ask you if you agree with those things. I'm going to ask you if you understand what it is that I just read.
I do not understand.
Okay, what don't you understand? That was wrong.
Well, I mean, I just stated where I stand.
Understand, but
Understand.
okay, those are your rights under the Constitution of the United States of America, as well as the Constitution of the state of Indiana. I am not going to ask you if you agree to them. I'm not going to ask you if you think they apply to you. I just want to make sure you understand those are your rights, if you choose to accept them or not. Those are your rights in this country, in this state. Do you understand that?
I do not understand.
Okay. We'll make for the record that you don't understand that. Also, that those rights have been read out in court, and so that you have been apprised of them. So, State, could you tell the defendant what he's charged with and what the possible penalties are?
Your Honor, he is charged by way of information that alleges that on January 31, 2026, in LaPorte County, state of Indiana, the defendant unlawfully, knowingly, or intentionally operated a motor vehicle upon a highway, a Ford Ranger with Michigan license plates D as in David, P as in Peter, T as in Tom, 9082, having never received a valid operator's license and not being exempt from those requirements under Section 9-1-4-27. That is a Class C misdemeanor. A Class C misdemeanor is 60 days in the LaPorte County Jail and a $500 fine.
All right, so Mr. Maitland, again, I'm not going to ask you if you agree with that or if you think you're subject to that law, which of course we've established that you are, but you understand what the state is saying that you did that's against the law. Do you understand what that is that they're saying, that you hadn't ever received a license?
I mean, he stated a statute. That's not law. That's not constitutional law. You just asked me if I understand my constitutional law, and I do understand my constitutional law. And what he stated is a statute that doesn't apply.
Okay, so let me stop you there. So the statutes are pursuant to the Constitution. We can have no statute that violates the Constitution of the United States or the state of Indiana. So you can make your arguments on the law. All I need to know is if you understand what the prosecutor said.
I do not, I do not understand.
Okay, so what the prosecutor did, the prosecutor read to you what they have charged you with, the state of Indiana, what they charge you with, and what the penalty could be for you.
Yes, Your Honor.
So we're going to make a record that that was read clearly out to you, and as the charge and the possible penalties, so that that has been done on the record. I'm going to enter a preliminary plea of not guilty for you. And are you going to hire a lawyer, represent yourself, or ask for the public defender?
I'm going to represent myself.
Okay, all right, we'll make a record of that. I do need to tell you, however, you have the constitutional rights to represent yourself in this court. However, you will be going against the state, and they are attorneys who are licensed, who are very experienced, who understand the law backwards and forwards. I just need to make sure that you've heard me say that and that you understand that. But it is your right to represent yourself. So we'll make a record of that. And we're going to reset your case to, as given about.
I have a record to show that I don't understand the statutes that the state is putting upon me, and I don't understand where the constitutional law is coming from, because I'm stating the constitutional law, and you swore under an oath of office, and so did the prosecutor. So if you guys don't want to upstand the oath of office, then we'll have to proceed from there.
Okay. All right, understood. Your next court date?
I just gave them a form to self-represent, just so you.
Okay, all right, so we got a form there, so you know what you need to do as a self-rep to represent yourself. And our next court date is?
March 25th at 12:45.
March 25th at 12:45.
Thank you.
Yeah, that's okay. We gave it to him.
I know you do that one sneaky. It's kind of mean. You gave it to the magistrate.
It is his.
Oh, okay, all right.
I didn't like that up.
Oh, that last number, I was.
Oh, listen, ma'am, if I could do that at my will, he would get a lot more cases.
We're off the record.
Yeah.
Okay.
Who's participating by phone?
On and for the record, I'm Houston LaShawn DeYoung, more beneficiary. I'm here in my proper person.
What's your first name?
My first name is LaShawn DeYoung. My surname is Houston.
All right.
I'm here in my proper person, my own right, and I haven't reached the age of majority. I'm a Moore Aboriginal, America's Aboriginal, Illinois national,
Is
but not a
Kimberly
citizen of the United States.
is Kimberly available?
Not a citizen of the United States.
Is Kimberly
Or the United
available?
States for the District of Columbia. Houston Kimberly Denise is deceased. I am the sole beneficiary and real party of interest in this matter.
All right, just a moment. Before the court this morning is the landlord's complaint to recover possession of property. The person entitled to possession of the property is the plaintiff due to a sheriff's deed of redemption.
I
The
object.
sheriff's
and deny.
deed, ma'am, please don't interrupt. I'm reading.
Not a ma'am.
Graf.
Excuse me. I'm a male.
Okay,
I object and
Sir.
deny.
sir, please don't interrupt. I'm reading from
You're
paragraph.
trying to put something on. You're trying to put something on the record. Has not been proven.
I'm going to have to
I
mute
object and
you
deny.
if
I
you
want-
continue to interrupt the court.
If you mute me, then you are violating my rights. You haven't even proven you have jurisdiction over this matter. You haven't proven you have.
Judges
personal
don't
jurisdiction
prove
or subject
things.
matter jurisdiction.
Judges don't
Excuse
prove
me?
things. Parties
Don't
prove
prove
things.
things.
That's correct.
No, the court has to prove that it has subject matter jurisdiction and personal jurisdiction over the subject matter.
You are now being
You
muted.
don't have to prove that.
Officer Denham? Thank you. As I was indicating, the complaint to recover possession of property received by the court on October 25th of this year and signed by plaintiff's attorney, who was present on the record, indicates in paragraph 5F that the plaintiff has a right to possession of the property because of a sheriff's deed, and the redemption period expired on September 8th, 2022. Is that correct, counsel?
That is, Judge, and the court will note on the complaint, we actually attached a copy of the sheriff's deed too. I believe it's the next document under the actual complaint.
Yes. So can you give me the history of the tenancy?
Yeah, can I do it informally, Judge, without having my client sworn, or does Your Honor want it to come from my client directly?
Anything that he says is impermissible and it's prejudicial. Statements of counsel in argument or in brief are insufficient for granting of a summary judgment or dismissal.
Your objection is over.
Matter. He is a third party in this matter. I want my objection on the record.
Your objection is on the record.
Time.
Your objection is on the record, and your objection is overruled. You're again being muted.
Is a third party.
I need her muted or him muted. Thank you.
Anything that is said scandalous and prejudicial and a
I am
right.
removing Mr. Houston from the hearing because of continual interjections, interrupting the court's proceedings. I will later consider whether to find him in contempt of court.
Judge, I removed his Chan's ability to unmute himself if you want to.
Thank you. That'll be fine.
Yeah, he can't unmute himself anymore.
All right. Okay, counsel, what I was asking for is basically when the tenant took possession and the historical facts as to the sheriff's deed and the redemption period.
All right, Judge. So the way, and I can have my client sworn in to identify for the court the specific.
Oh, sure.
facts. The actual scenario is the homeowner, which I believe are that the Houstons were residing there, and they had a mortgage. The mortgage fell into to default, and the property was placed. For foreclosure, and it went to a sheriff's sale. And my client was a successful.
It went into default on the mortgage or on the tax bill?
On the mortgage, Judge.
Okay, and who held the mortgage?
Genesis it's Genesis Credit Union, as reflected in the sheriff's deed.
All right.
And my client, when it was put up for public auction, my client actually was the highest bidder, concluded that transaction through Oakland County, and then the sheriff's deed on the mortgage sale was issued and then ultimately recorded after the 6-month period of time. So we're here today. No, there's been no participation, and the court will note, I mean, you heard a little bit this morning on the record, which is why you muted the defendant. There were some documents filed in this matter by Mr. Houston, and if the court has read them, that's great. But it's pretty much it's the kind of things that he's saying, nobody has jurisdiction over him. You can't take away the property and whatever. Bottom line is he had a mortgage, went into default. We were the successful bidder at the sheriff's sale. 6-month period of redemption has passed. No payments were made, and we want to take possession.
Okay, thank you. Mr. Houston, I have a question for you, and that is whether within the 6-month redemption period, you did anything to redeem the property. Officer Denham, we need Mr. Houston unmuted.
Mm-hmm. I've entered onto the record in that first case that third party was just talking about, proof that mortgage has been discharged by Genesis Credit Union. And it was discharged before October. It was actually discharged in July.
What do you mean by discharged?
It was discharged. The mortgage is paid in full, discharged. And it was entered into the record of the first case.
I have several filings.
It was even over.
Did you file that?
The redemption period was over. I didn't file it over. I filed it in the first case. It's still evidence in that first case that he referenced.
One moment. Attorney Hirschfuss, am I saying it right?
Hirschfuss.
Hirschfuss.
I still object to him even speaking in this matter. He's a third party intervener.
He's going to speak. That's my decision.
Everything that he
Please
said
don't
is
interrupt.
scandalous and
Okay, you're muted again.
prejudicial.
Sir, did you obtain a copy of the original file?
No, let me just indicate for the court what the discharge he speaks of.
Yes.
The Genesis discharged the mortgage because we paid it off. So there is it's, by the way, it's not a discharge, it's called a satisfaction of mortgage.
Yes.
And it's dated on May the 24th, 2022, and recorded in Oakland County Register of Deeds office on June 2nd, 2022.
All right. I have not yet adjourned it to continue, sir, but go ahead. You were going to read the discharge.
It says satisfaction of mortgage. Know all men and by these presents that Genesis Credit Union of Auburn Hills does hereby certify that a certain mortgage dated May 3rd, 2018, made and executed by LaShawn Leon Houston and Kimberly B. Houston, husband and wife, to Genesis Credit Union and recorded in the Register of Deeds office for the County of Oakland, Michigan. The lot and everything, the tax parcel and all that is fully paid, satisfied, and hereby discharged as of today's date, 5/24/2022.
Thank you. And that is the same document that the attorney for the owner has read into the record, sir. And so he's indicated that it's his client, Mr. or Shepherd Properties LLC, who satisfied that mortgage by paying it off. In what amount, sir? In what amount, Mr.?
Judge,
a deed or bond found with the debtor is presumed to be paid. He has no mortgage with his name on it. He has no proof that he's an adverse party or that he's a bona fide party to this matter. He has no proof that he gave any consideration to the sheriff, and the sheriff gave any consideration to me in order to sell my private property in the first place, which is actually owned by a trust, and the Oakland County Register of Deeds and the Oakland County Treasurer has been notice of that property has been transferred into trust as of 2021. So at what point in time did the sheriff give consideration to me or my trust for my property in order to sell it in the first place?
Sir, you would have to consult an attorney about that process.
I don't need to
However,
speak to an attorney. I'm here my own proper person in my own right. I'm suing you this. I don't need no attorney. He's no guardian over me. I'm not a minor.
all right. Thank you.
Now, furthermore,
You're going to be
Genesis
muted
Credit
now
Union
in order for me to address
Can I have
some
your
of what
name?
you.
Can I have your name, please?
My name should be on the screen, or you're on the phone.
I
It's-
don't have the screen open. I'm on a telephone. Can I have your name, please?
Yes, when I'm ready
The
to
name
give it
can't
to
speak.
you. When I'm ready to give it to you. Please mute Mr. Houston so that I can address his issues. All right, so we will adjourn this until, or continue it on January 18th, 2023 in the afternoon. The docket time will be stated on the notice of hearing that is mailed to the parties and counsel.
very good, Judge.
And the reason for the continuance is for the plaintiff to present the satisfaction and the recorded deed. And Mr. Houston, my name is Judge Sheila Miller Martin. All right, we can unmute Mr. Houston before closing for today.
Could you repeat that, please? Repeat that, please. You said Sheila Miller Martin.
That's correct.
Have you taken an oath to uphold the Constitution, Judge?
Sir, I don't answer those types of questions. I'm not a
Have you
witness or
taken
a
an
party.
oath? Have you taken an oath? That is a question for you, Judge. All you
Goodbye.
have to do is say you've taken an oath.
Thank you. Okay. Can you tell me again how you want to be addressed, just so I can add notes in? Is
You
it
can
just
call me
use
Timothy.
Timothy? Okay, cool.
That's it.
Sure.
All right. So
Yes,
they
first.
is the court attempting to enter a plea on my behalf
We
because
have to. Yeah, we
that
have to.
no. I would not, again, I specifically said I am not pleading to anything. Okay. Now I'm
Yeah.
not entering any plea whatsoever, not of guilty or non-guilty or no contest. I am not entering a plea whatsoever. If the court
You're
is
not.
attempting to enter a plea on my behalf, how do
Yep.
I get a recording of these proceedings? I would need a recording of these proceedings so that I can submit it to the Federal Court of Complaints.
Yeah. Give me a half a second. I'll find the law for you. Is it 45 or 45A? Yeah, the Texas law says if somebody refuses to enter a plea, the court has to enter a plea of not guilty for them.
What law is that?
It's Texas
Is
Code
that a
of Criminal
statute? Is
Procedure.
it a law or is it a statute?
I'm not playing that game with you.
No. I'm asking you a question. Okay, well, tell me
It's
what
a
it is.
Texas
It's
statute,
45
Court of
what?
Criminal Appeals. So Texas Code, Texas Code of Criminal Procedure is the statute. Texas Code of Criminal Procedure.
Okay, so it's a code. Okay, 1 second.
But I mean, all of these issues are pretrial issues that we discuss. I'm fine talking with you now. That's perfectly fine. But are issues that we can discuss at a pre-jury hearing.
Well, in order for me to sign that paper, I would have to.
I don't need a
agree
signature. I
to
told
you
my
guys
clerk.
entering, saying that. Well, she's saying that I have to sign it, and if I don't sign it, I'm going to have a warrant out for my arrest. And I told her I did not enter a plea of not guilty,
No,
so
you're good.
therefore I can't sign it.
My clerk's I'm gonna have my docket clerk go up there and help solve that problem. We don't need a signature from you.
How do I get a recording of these proceedings?
I mean, you can file that request. What is it that you need? Yeah, there we go. I found it. I can show it to you. Hold on.
I just need to know, how do I get a recording of this for right now? Right now, I really want to know, how do I get a recording of these proceedings? I need to get this.
Yeah, I mean, you could file that request in writing. There it is. I'm showing it to you on the screen.
With who?
To the court. Yeah, to the court. Yep. If a defendant refuses to plead, I'm showing it to you on the screen. If a defendant refuses to plead, the judge or justice shall, I have no option, shall enter a plea of not guilty.
Okay.
I don't know how to interpret that any other way. I mean,
That's
it's
fine.
a statute that's.
Yeah. You guys, you do what you feel you have to do. So I'm just trying to make sure, if I submit a request for the recording, this recording of these proceedings to, I guess, is it the Denton Municipal Court clerk?
Sure. Yes.
All right. And I'm going to be able to get a recording of these, of saying that I did not enter a plea and that you guys had to enter a plea. It's a code that you guys have to follow. Code, not any law.
Yeah, I'm not going to guarantee an outcome, but that's where you would submit a request, is through the court clerk.
Oh, so you guys don't guarantee that I'll get a copy? Okay. There's no guarantee that I'll get a copy of these recordings.
Yeah, I can't give you legal advice on how to handle a process issue.
No.
But you can submit that request to the court and the court will review it.
Okay, so, and is somebody coming up there so that I don't have to sign? And is there going to be a warrant out for my arrest if I do not sign?
No.
I
don't like talking about warrants. Yeah.
Timothy.
Well, she told me.
Timothy, I'll be
Yes.
up there in just a minute.
Bailiff's
Okay.
going to
Walk
help.
down to the courts with you and we'll get it taken care
Because
of.
I'm going to show up for my pre-trial.
Just hang on.
And I'm going to
We're
make
done
sure
here,
I
Tim.
want
We'll
to
be
be
there in
a
1 second.
jury trial. I'm going to follow all the processes. It's
Perfect.
just, she said I
Yeah.
had to sign
No,
in
you're
order,
good.
or I was going to have a warrant. And
Yeah.
on that paper, it says plea of not guilty. And I never, I specifically.
Cross that out. If you don't want to sign that, cross that out. Yeah, you can cross that out if you're not entering a plea. But you don't have to sign. I'm telling you, you get to take that paper home with you without your signature on it. But I just want you to have the court date. That's my only thing. I want you
Okay.
to know when to come back, but I don't need a signature from you.
And I
Like,
just want to make sure I'm not going to have a warrant out for my arrest by
No.
not signing it.
no. Yeah.
Okay.
Yeah.
And I'm
If
gonna
that was
submit
told
a
to you, if that was told to you, we'll fix that problem. But yeah,
Okay, I'm gonna submit a request for these recordings.
if you want, yeah. Bailiff is coming just to make sure that you're good and that you have the paperwork that you need. You're not in trouble or anything like that. But he's the nicest person in the
I
world.
appreciate Officer Todd
Yeah.
coming to help me. I appreciate it. I'll welcome him.
Perfect.
Okay, that's it. I
Awesome.
just want to make sure I'll be there for whatever the trial date is,
Perfect.
but I'm not signing that paper that says I pled guilty because
You don't
I
have to.
explicitly did not.
Yep. You don't have to. You're good.
All right.
I'm not threatening you. Say one more word and that's 30 days. 30 days.